SJC-12669 in the matter of a juvenile.
Mr. Hahn, good morning.
Yes, good morning, Chief Justice and Associate Justices. Peter Hahn on behalf of the juvenile, Lauren Russell with me. May it please the court. An act relative to criminal justice reform became law last year, April 13th, 2018. One of the provisions of that act was to amend the definition of delinquent child in Massachusetts General Laws, Chapter 119, Section 52. And that is for juvenile delinquency proceedings in juvenile court. One of the changes was to exclude a first offense of a misdemeanor for which the punishment is a fine, imprisonment for not more than 6 months, or both. For the purpose of this argument, I'm going to be calling those qualifying misdemeanors as a shorthand. The juvenile in this case was arrested for and charged with unlicensed operation of a motor vehicle. The maximum punishment for that is a fine. And when he was scheduled for arraignment, his attorney moved to dismiss that charge based on this new definition of a delinquent child. And the argument was that unlicensed operation of a motor vehicle was one of these qualifying misdemeanors. More specifically, trial counsel argued that a prior adjudication was required, and that there was no prior adjudication for the juvenile.
A hypothetical?
Yes.
So my 13-year-old neighbor doesn't like me because I tell him to get off my lawn all the time because I'm a grumpy old man. He takes a rock and throws it through my garage window. My garage window is decidedly under $250, so it's malicious destruction of property under $250, a misdemeanor. First offense, he can't be charged, right?
I disagree. That is a misdemeanor, but the maximum punishment for an adult is more than 6 months imprisonment. So that is not one of the qualifying misdemeanors.
But the maximum punishment is
Not more than 6 months.
2 months, 2.5 months.
No, for yours.
For mine, my hypothetical is 2.5 months.
For yours. I'm sorry if I have that wrong. Then yes, if that is a qualifying misdemeanor, then the juvenile court would not have jurisdiction over that if there's no prior adjudication, on my argument, for malicious destruction of property valued under $250.
Right, and I think the Commonwealth would agree with that for the first time, all right? Next month, he still doesn't like me. He throws a rock through my same garage window that I just fixed. Okay?
If that juvenile does not have an adjudication, a prior adjudication for that same offense, then the juvenile court would not have jurisdiction over that.
All right. The next month, he takes a rock and throws it through my garage window. What happens?
If that juvenile does not have a prior adjudication for that offense, then that the juvenile court would not have jurisdiction over that offense. What we have to look at here,
I just have to buy a whole bunch of windows.
What we have to look at here is statutory construction around this wording of this.
Doesn't it get worse? And then, name every other misdemeanor. How many misdemeanors are there? Thousands, right? Every day he commits a new one while he's throwing rocks through Justice Gaziano's window, right? All those misdemeanors fit that definition you just cited. He gets to do that every day, too. Justice Gaziano's got a lot of problems at his house, doesn't he?
First of all, there aren't thousands.
But how many are there?
In juvenile court, for the qualifying misdemeanors that you normally see, they're about 15 to 20.
I'm just taking your argument to the extension, right? He can commit every other misdemeanor, too, right? Under your view, he gets one shot at every misdemeanor.
That is an extreme hypothetical. In juvenile court, you do not see juveniles who are accused of all of the different possible qualifying misdemeanors.
You're saying he gets all those, aren't you?
As long as there's no prior adjudication for that offense that you're talking about, then the juvenile court does not have jurisdiction over that.
How about this? Let's say that the 13-year-old that doesn't like Justice Gaziano doesn't live across the street. But going back to the last case, he lives down the highway. And every day he brings his rock into the car with him. He doesn't have a license. and he operates negligently to endanger driving 100 miles an hour because he's so anxious to get to Justice Gaziano's house to throw the rock. So every day he operates negligently to endanger, every day he doesn't have a license and he's driving, and every day he throws the rock through the window. But he has no prior adjudications, can't be prosecuted in the juvenile court?
Yes, that case can be prosecuted in the juvenile court. Unlicensed operation of a motor vehicle, like in this case, which is the one charge, the court did not have jurisdiction over. But in your situation, a negligent operation of a motor vehicle is not a qualifying misdemeanor. So in that case, the court would not be able to...
Penalty for operating negligently to endanger.
I do not know that off the top of my head.
So the legislature did this. We have to respect it. The question is what they meant. Your view is that what they meant essentially is that you could, as long as an individual does not commit the same misdemeanor twice, that he can never essentially be deemed a delinquent child.
I want to be clear about something right now. There are plenty of juveniles who could have a prior adjudication for the offense for which that juvenile could come in a second time. And in that situation, the juvenile...
More though, right?
Excuse me?
But that's because the law changed. It's because the
The
law
law
was different.
changed,
Okay,
but
so let's
when
imagine
the-
let's imagine it's 5 years from now.
Yeah.
So 5 years from now, that person would never be deemed a delinquent child because that person could never get a second adjudication because they could never be deemed delinquent for the first.
That's true. The Commonwealth calls that an absurd result. It's not an absurd result. It's a rational result. In fact, it's a reasonable result, and it's consistent with the statutory or the legislative intent of this new statute. So if you could bear with me. These minor misdemeanors, these qualifying misdemeanors, if an adult were convicted of them, the maximum punishment would be imprisonment for 6 months, would be a fine, or both. So in juvenile court, the maximum punishment for that juvenile being charged and adjudicated of that would be a commitment to the Department of Youth Services in most circumstances until that juvenile's 18th birthday. So we are looking at the disparity between really minor misdemeanors with not serious or comparatively less serious punishments compared to a juvenile who could be committed to the Department of Youth Services for years.
So
And it would be
your argument is that the legislature intended and in fact did decriminalize all misdemeanors of this sort.
Over time, that is true. So essentially, the effect is a phase out. So we have these...
But I don't get it. Why would they have removed the word first offense? If you're right, why did they use the word first offense? Because they could have easily done what you wanted by just writing violation of a municipal ordinance or a town bylaw or a misdemeanor for which the punishment of a fine is not more than 6 months. Wouldn't that have been the simple way to do what you're talking about?
The legislature did not do that. If the legislature had done that, we wouldn't be here. This case is about statutory construction, statutory interpretation. So with the rules that you have, consistent with the legislative intent that is throughout the criminal justice reform bill, especially the juvenile-specific provisions, to keep children out of the juvenile justice system because of the inherent negative effects of it, including for low-level offenses, and those being minor misdemeanors, these qualifying misdemeanors. We can't question what the legislature should have written. The legislature did not write it. So we have the language that's presented to us in the amendment.
So let's I mean, the legislature was thoughtful in the criminal justice reform, so I think we have to respect it. And we do have a principle of statutory adjudication that we don't interpret something to be absurd. So let me present to you a possible alternative interpretation that neither of you have presented. What if a juvenile has committed an offense which is a felony and has been found to be a delinquent child because the child has committed a felony, and then 6 months later throws the rock at Justice Gaziano's house? Is it your view that that person, having since the misdemeanor now would not be his first offense, he would have an earlier adjudication. Would he not be able to be prosecuted for that because this is effectively now his second offense, his second juvenile, he's already been deemed a delinquent child and now he's committed a misdemeanor?
The juvenile court would not have jurisdiction over that offense. First offense of a misdemeanor, those words have to be read together. So if that juvenile
we
did
have
not...
a choice then. I mean, we have to figure out, so we have to deal with the fact if it's first offense of a misdemeanor and there can never be a first offense, then we have to reinterpret what first offense means. Or we can interpret first offense to mean the person has not been previously adjudicated delinquent.
First offense requires a prior adjudication. We have a class of juveniles right now for which that would apply. Over time, that would be phased out. And if that is the interpretation today, and the legislature believes there needs to be a fix to the language, then it's up to the legislature to fix that. First offense can't require just a probable cause determination, as the Commonwealth argues. First of all, probable cause is a legal standard around facts and alleged facts, whether or not there was a proper arrest based on probable cause, whether or not there's a complaint that should proceed based on probable cause. This is not a legal standard that relates to jurisdiction. I believe the Commonwealth and I agree that this is a jurisdictional change by a change in the definition of a delinquent child.
So you're interpreting first offense of a misdemeanor to be a phrase which can't be chopped up. It can't be a first offense and then of a misdemeanor. Your view is that it has to be first offense of a misdemeanor.
Definitely. I don't believe there's any way to separate out those two aspects of that exclusion. They have to be read together, first offense of a misdemeanor.
Even though the person who, the child who I've described has had a first offense, which is not a misdemeanor.
Yes, it is first offense of a misdemeanor. The thrust of the intent behind criminal justice reform, including the juvenile-specific aspects, were to keep kids out of the system for low-level offenses.
I understand that, but that's why I raised the possibility of interpretation which says when a kid is in the system, having been previously adjudicated delinquent because of a serious offense, then lesser offenses which would not otherwise make that child a delinquent child may now make that child a delinquent child. I'm positing. I know who was involved in crafting the legislation. They're thoughtful people, so it's not fair to say they were not thoughtful. And I'm trying to figure out something that would be a thoughtful interpretation of what they wrote.
I didn't mean to say or suggest
No,
that
but
they
I mean,
weren't
but
thoughtful.
we're faced here with the risk that we have, and a somewhat absurd view is that the legislature intended one to do this repeatedly with no consequence. And I guess in my example, if you never committed a felony, you could do it repeatedly. But at least in my example, there's the possibility for a kid who's already been adjudicated delinquent to again be adjudicated delinquent if he has previously been adjudicated delinquent and then commits a misdemeanor of this type. And so, but your view is that's outside the scope of the language?
Yes, that is outside the scope of the language, and is ultimately up to the legislature to amend that language again if what ultimately results out of this case is different than what the legislature believed.
What do you think the goal or the intent of the legislature was in crafting that statute the way it did?
To keep young kids out of the juvenile justice system, to keep kids charged with violations of a city ordinance or town bylaw out of the juvenile justice system, which were previously in the juvenile justice system, and then for the provision here to keep kids out of the juvenile justice system for low-level offenses.
Even Justice Gaziano's neighbor?
Excuse me?
Even Justice Gaziano's neighbor who throws rocks every month?
As long as it's a qualifying misdemeanor and that juvenile does not have a prior adjudication for that offense, that juvenile might have a prior adjudication for that offense, but if that juvenile does not have a prior adjudication, then the juvenile court would not have jurisdiction over that.
So pragmatically, what would happen? I mean, the juvenile court has jurisdiction over non-delinquent matters. Is there anything that the juvenile court could do with regard to this child who
Yes.
is battering poor Justice Gaziano's garage?
Yeah, so there is, for example, child requiring assistance cases in juvenile court. So if a child is not obeying the rules at home and presumably parents involved there, then that parent could bring that child to the court. If there is another offense that's
Anybody
not
other
a
than the
qualifying
parent do that?
misdemeanor.
Could anybody other than the parent get that child into court?
For a child requiring assistance, it's just parent or school.
Just parents.
But
Or school?
or school. I don't know off the top of my head, but there may be another offense that's not a qualifying misdemeanor that covers your situation. For example, if criminal harassment, if it happens more than once, 3 or more times, then you have the possibility, if not the likelihood, of having that case go into juvenile court.
What about
So
all
it would
the
address that situation.
circumstances- What about all the circumstances in various statutes where first offense is interpreted not to require a conviction?
My review is that in most situations, first offense does require a prior conviction or the equivalent of that in juvenile court and adjudication.
Okay, but we're going to hear in a minute all the ones that don't.
So I believe that for the purpose of interpreting first offense in first offense of a misdemeanor, the criminal statutes that that the legislature was presumed to be aware of, the predominant reason for those, the predominant interpretation of those, the predominant language in those statutes links to a prior conviction. So I disagree that there is any other prevailing view of what first offense means, whether it's the dictionary definition from Black's Law or the usage of that term within the criminal laws of the Commonwealth.
So for everyone, so remember, we can't have the interpretation be absurd. So if the legislature is going to decriminalize misdemeanors punishable by 6 months or less, which is a significant thing from this point forward for anybody who doesn't previously have one. They're going to decriminalize all of those misdemeanors. You don't think that they would say that directly?
They did not say that directly. So I don't want to question that, but the legislature can go back and clarify the language if that's what the legislature believes that it needs to do.
Isn't one of the problems, and it's something Justice Kafker raised, is when you look at the statute within the same paragraph, when they did say the ordinances, they did clearly say it shall not include, and they didn't carry that language over in the same paragraph to the misdemeanors. Instead, they chose to use those words that we're talking about, the first offense. So as a matter of statutory interpretation, when you read through it and you have the shall not include, and then it doesn't carry that language over, they could have easily just said shall not include misdemeanors.
They could have said that. They could have said that. They didn't say that. What we have is the language that's presented to us. But there are also problems with the Commonwealth's interpretation, I was starting to say before, around the use of probable cause as essentially a standard in other realms, not jurisdiction. And then also there's...
They surely have a problem that first offense usually involves second and subsequent cases, and you've pointed that out ably, that those usually require adjudication and convictions.
Right. The other thing is, if the Commonwealth, if it's a judicial determination of probable cause under the Commonwealth's argument, and that case goes in, then that case is not going to be arraigned. So there won't be a record on the juvenile's court activity record information or carry. And so then in most circumstances, the Commonwealth may not be aware of whether or not there was another judicial determination of probable cause without there being an arraignment on the carry. Now, it may be that it's the 13-year-old that keeps coming back and they know about it.
But you don't want that. You don't want people being arraigned for no reason, right?
Well, exactly. So that was my next step, which is you don't want, certainly we don't want, and certainly the legislature doesn't want or didn't intend for those false positives or erroneous arraignments to happen because of all the negative implications of being in the juvenile court.
Which means they can't be arrested either for the crime, because they'd be arrested as a delinquent child, but they would not be a delinquent child.
Exactly. So there are broader-based implications of whatever the determination is here as to what first offense of a misdemeanor means. I do want to make sure that I focus on the juvenile in this case before we wrap up. It's clear that the juvenile in this case has this one charge of unlicensed operation of a motor vehicle. Not only does he not have any prior adjudications for any offense, he has no prior adjudications for this offense. He has no prior charges for this offense, and he has no prior charges for any qualifying misdemeanor offenses under the law. So it is
And you
clear
argue,
that for him,
you argue it has to be the same crime, correct?
my argument on behalf of the juvenile, as well as the interpretation, is that it has to be the same crime. But even if you were to decide other than that, for the juvenile in this situation, there's no qualifying misdemeanor, there's no unlicensed operation of a motor vehicle prior, there's no adjudication. So his case had to be dismissed in the circumstances and facts of his case.
All right, thank you.
Thank you.
Ms. Semel?
Good morning. May it please the court? I'm Catherine Semel, and with me is ADA Heidi Sylvanowicz, who is the trial attorney in this case. The juvenile court found in this instance that exclusion for a first offense of a misdemeanor applies only when there's been no finding of probable cause previously against the juvenile. And I think I'll start with the easiest part, which is the part where
But let's focus on this particular juvenile. I gather there was no finding of probable cause apart from this particular charge for him, is there?
Yes, there were. There were several cases. He had several prior cases, several that were dismissed for distribution of drugs, one that is still open for breaking and entering with intent to commit a felony.
So no adjudications.
No adjudications,
But
correct.
you're saying previous findings of probable cause suffice?
Right, which is what the,
And were those charges ones which fit within the category of 6 months or under?
they were not, Your Honor.
So those were all charges which would not fall within this category?
It's my understanding, yes, Your Honor. And I think that the question that you posed, Chief Justice, is basically what was assumed by the juvenile judge in this case, and not expounded upon by me in my brief, for which I apologize. But I think her understanding was essentially that the first offense, that the language about the 6-month misdemeanor meant this offense. And I think she assumed there was no discussion, there was no challenge, so there was no discussion that that was the focus, and that it didn't mean to limit what was the prior offenses. Again,
But the prior offenses would have to be ones with more than 6 months. So, I mean, what you're saying then is that if during the course of the adjudication of this case, this particular juvenile were found delinquent for one of the other offenses, or at least there's only one pending, for the pending offense, then he could be found delinquent for this, but not otherwise?
I don't believe he needed to be found delinquent for the prior offenses. I think that if there was a prior finding of probable cause of any range of crimes, that
How does that work? So the juvenile lives down the Cape, and he's arrested for first offense. He never done anything before, or he's not arrested. He can't be because it's a misdemeanor. He certainly isn't arraigned. There's no carry record of that. And then he moves to Western Mass. And he does something in Western Mass. How are you going to know whether or not this is his first offense? And then he moves to Essex County.
for just a misdemeanor.
Yeah, how are you going to track this?
I'm not sure. I believe that internally, the courts are tracking them and keeping records with that in mind. But I don't know how it would work.
The
I'm not sure.
legislation contemplate this?
Do they do they contemplate that problem? No, I wouldn't say that they thought out how this was going to be implemented. Exactly. I think it's very clear what their intention was, but the implementation is a lot trickier.
But those mechanics about tracking when people have committed crimes and it's decriminalized because of the operation of the statute, legitimately so, we don't know how that's done. Or you don't know how it's done.
When it doesn't go to the point of an arraignment?
Right.
No, I'm not sure how it could be. I doubt that it could be done perfectly.
Then how does this work? Other than the person stays in the same town and the cop says, yeah, I arrested him last week. This is the guy that throws a rock through Gaziano's garage door.
I'm not sure that it would work perfectly. I mean, when it doesn't progress beyond a clerk's hearing, I'm not sure that it would. But of course, to the extent that it doesn't, that would inure to the benefit of the juvenile. and certainly would not detract from his rights in any way. And I think the courts are struggling to try to figure out how to implement this in an effective way.
How do we get, don't we have to add the words probable cause to the statute to, I mean, his interpretation, we got to subtract words. Your interpretation, we have to add words, right?
A little bit, Your Honor. I agree. I think this is a working backwards type of exercise more than a working forward. I mean, certainly offense is not synonymous with conviction. I think that's clear under any plain understanding of the word. And I think in this case, if you were to substitute conviction or adjudication for offense, you get to absurd.
It is in all the second and subsequent statutes. Offense is synonymous with an adjudication.
Most of the statutes that deal with that talk about being convicted of a sex offense, convicted of a prior offense. The terms are not used synonymously. Occasionally, they're shorthanded, first offense, second offense, but most often it is spelled out in that way. And I think that the shorthand offense is a conviction is both atypical and in a particular context of sentence enhancement when you're dealing with convictions. And we don't have a lot of good examples, or any, but you know, certainly it is a different context here when we're talking about threshold jurisdiction, which is essentially a probable cause finding. So I agree that you just can't get to probable cause, that an offense means probable cause, but I think you can get very quickly away from an offense means an adjudication because it doesn't make sense in this statute, and because it's not the common understanding. And then you're left with, well, what is an offense? I mean, certainly we don't want it to be just an arrest. That would not be favorable to juveniles. So I'm not sure what other standard you could implement that would be more favorable to a juvenile that is not an adjudication, which I would just suggest is the only clear thing.
So even if we have a probable cause finding and then he's exonerated, is that still ineligible? That still satisfies your definition of probable cause, right? Even if he.
Yes.
See, that's where it gets tricky, doesn't it? So we have any probable cause finding, even those that don't end up with a delinquency finding, are still an adequate basis, right?
Yes, and I think it's the only reasonable alternative, and that I think that it presumes that it requires that there was some finding, that there is a rational basis for this charge, and that is enough to implement the charge in this case, and that.
But you still have a problem because, let's play it out. Let's go back to Justice Gaziano's home. So the kid throws it. There's probable cause to believe he did it, but it's his first offense. So why would you even get to a probable cause finding? Because the first probable cause finding is not going to make him a delinquent child.
It's not, and I think that the, I'm sorry. No, I take that back. My understanding of the process is this, that the case goes in front of a clerk magistrate. The magistrate looks at this offense and says, is there probable cause for this offense? The magistrate, if there's not, then the juvenile is done. If there is, then the clerk will look to the prior carry record to determine whether or not this qualifies as a first offense, whether there are prior findings of probable cause. There are prior findings of probable cause, then the complaint will issue.
This is the statute?
No, that's just my understanding of the process.
But the probable cause determination is probable cause to believe that he or she is a delinquent child by reason of having thrown a rock, not probable cause to believe he or she has thrown a rock. The only adjudication that can happen is delinquent child, and this is the definition of delinquent child.
Well, if I think that the clerk is first looking to see. I understand, but it seems to me that the question whether the juvenile can be proceeded against as a delinquent child goes to whether a complaint can be issued, and I think you could distinguish the two. Finding that there is probable cause that this offense was committed does not mean that a complaint should issue. And I think that's why it's a two-part consideration.
Do we have any legislative discussion of this? No guidance whatsoever out there when they passed this?
The only things I saw were generalized statements of what we all, I think, know and agree. I don't think anybody would quibble, and I certainly would not quibble with the idea that the overall aim of this legislation was to reduce juveniles' footprint in the traditional juvenile justice system in a myriad of ways.
Is there any variation in the language in the provision? Did it go through an evolution that might provide us some information?
Not that I know of, Your Honor, and I will say I know that there is some pending legislation, on the statute, but I don't think it actually attacks this core language. It kind of works around it in a way that I think they're attempting to clarify it because they are aware that there have been issues and confusion about it, but I don't think it changes this core language, to be honest.
Can we go back to the logistics of what you described? So, child throws the rock at Justice Gaziano's garage, is arrested, brought before the court. The court, under Umberto H., says, I want a determination, or the defense or the counsel says, I want a determination of probable cause before the carry record is created, before he's arraigned. So the court looks at the complaint, says there's probable cause. You're saying that there would be then an arraignment, even though this is the first offense and he can't be a delinquent child?
No, not at all, Your Honor. I'm sorry if I was unclear. What I meant was that the magistrate essentially has a two-part job to determine before the complaint even issues. The magistrate is charged with determining whether there's probable cause that this offense was committed and also whether or not it qualifies as a first offense.
And you think the juvenile record, the docket is going to say, even though there's no arraignment, that I find probable cause, but I find that this is the first offense, and therefore I dismiss the complaint? It'll say dismissal of the complaint, correct?
I don't think a complaint will ever issue. Yes, essentially, yes.
And that record is supposed to enable people to go forward and say, well, the judge made a probable cause finding before the judge dismissed the complaint, and therefore that's the first offense?
Yes, for this purpose, yes.
And it doesn't appear on a carry, of course.
It would only,
And then,
in that
and
instance,
then nobody knows about it.
in that instance, it would just be a matter of internal record keeping, I think, of the court, which is not a perfect situation, certainly. But I think it is the only reasonable way to implement this legislation. I think this is what Judge Phelan Brown found, and I think that's what the juvenile court is doing to try to address and implement this legislation, which certainly didn't mean to decriminalize them for all the reasons that the panel.
The juvenile court has to go through its own internal paperwork or forecourt and try to figure out whether or not this person's ever was not arraigned.
Going forward, I mean, in this case, of course, we have a carry record for this juvenile. But yes, in general, the way it stands right now, yeah, that is my understanding of what would have to happen if there is no carry record outstanding for the juvenile.
And what if there is a carry record indicating a prior adjudication of delinquency for what would be a felony, and the person comes forward again with this? Do you think the fact that your brother says, oh, it's got to be the first misdemeanor, not simply the first offense? Do you share? Well, I've presented to you, I posited an alternative view, which is that if there's a prior adjudication of delinquency, then you can go forward on this misdemeanor.
And I would agree with that view, except I don't think it requires an adjudication. But as to the point of your question, which I think is primarily what if it's a more serious offense, which was actually the case here, I think that it is a case of this court having to interpret a statute so as to implement it in a sensible fashion. If it were not the case that a more serious offense would suffice, then you have an instance, of course, of a juvenile who comes in and has a prior misdemeanor, and then is charged in this case with, unlicensed operation, and you can go forward against them. But you have a juvenile with a very serious prior offense, adjudication or probable cause, depending upon the analysis that this court adopts, and you couldn't go forward. And that is in no way consistent with the intent of this legislature, which I think is clearly to give you a pass. Give you a pass on a low-level offense if you don't have prior involvement in the juvenile justice system, not a wholesale exclusion from this system. And I would note, just as a practical matter, because I'm being educated about this myself, that the process that the complaint issues, and really what we're talking about, I think, primarily is whether a complaint should issue. All of the other remedies that the legislature put in place to protect juveniles are still in play. Judicial diversion, the DA's diversion, which was, in our office, and probably most offices years before this came about, those are all in play after a complaint is issued and before arraignment. And I think it's important to focus on what we're talking about, which is just the issuance of the complaint in this instance. If the court has no further questions.
Okay,
Thank you very much.